Good afternoon, ladies and gentlemen, dear guests and visitors, dear colleagues. On behalf of the organizing committee of this conference, Ivano Alogna and Alina Holzhausen from the British Institute of International and Comparative Law, and Matteo Vermelia and myself from Hasselt University, its Environmental Law Unit. A warm welcome to all of you, those present in this room, and the many present online. It is a pleasure and an honor to have you with us to discuss climate change litigation in Europe as it currently stands, and looking for the more relevant trends in a comparative perspective and a sectoral perspective, with the aim to reach insights on the way forward. In view of the climate emergency, we direly need such insights. Our afternoon program hosts keynote panels and a roundtable discussion with practitioners, but let me first greet and welcome Professor Bernard van Heusden, Director of Hasselt University, who in a previous life directed the Environmental Law Unit. Bernard, it is truly a pleasure to have you with us. Many thanks for coming. The floor is yours for some introductory remarks.
Okay, thank you very much. And on behalf of Hasselt University, a very warm welcome to the few people here. Unfortunately, we're still in Corona times in this hybrid form, the people here present in the auditorium, but also the many people, and I've heard that we will have in the next 2 days around 300 participants online. So to all of you also at home, welcome to Hasselt University. It's a pleasure also on behalf of Petra Faure, our Dean, to welcome you. Actually, we're in a full trial day. In 1 month time, we have an institutional review procedure with an external review board. And today we have a trial day, and Petra, the Dean, is currently sitting in a panel, so she couldn't be here today. But I want to welcome you also on behalf of her. I think it's very nice that we can have conferences again, be it in a hybrid form. So I'm happy to see some of you at least already here. And it's a bit of pity for all those not being in Hasselt. And I would definitely encourage you to come one day to Hasselt University. We are here located in an old prison. Actually, this is a former prison. And you can still see, if you walk around in the building, you can still see the former prison cells. And so definitely have a look around. This was used as a prison until the 90s. And then for 10 years time, it was abandoned. And then in 2005, actually, we started refurbishing the prison. And then in 2008, use it as the new law faculty. Because actually, Hasselt University has 7 faculties. And our most recent one is the Faculty of Law, created in 2008. And the law faculty is a cooperation between Hasselt University, but also with Maastricht University and KU Leuven. So Leuven University, Catholic University of Leuven. We also have some colleagues here from Maastricht and from Leuven today and tomorrow who will join us for discussions, keynotes, etc. So we're very, very happy that they also join us. I want to say a few words indeed also on Carole and Matteo, who are organizing this conference together with the 2 colleagues from the British Institute for International and Comparative Law. Indeed, as Carole mentioned, in October 2020, I became rector, president of this university. And so 1.5 years ago, I can say that Carole and Matteo took over my role as a head of the Environmental Law Unit. So although I'm now not really involved anymore, still slightly, with environmental law, energy law, climate change law, etc., I'm still following it. And I see that Carole and Matteo are doing a great job to keep on putting the Environmental Law Unit on the European and international map. So I want to congratulate them with this conference. If I look at the topic, if I look at the whole list of participants, I think that's very nice. Regarding the topic, it is a very topical issue. Climate change litigation. I think any country, or at least a lot of countries now have their big climate case and probably several smaller climate-related cases. We also have definitely our big climate case with over 60,000 citizens as parties involved, inspired by the well-known Urgenda case, which started in the Netherlands. And so it's very similar, also with the same lawyer involved, Roger Cox. But that's a case, for example, and I can imagine that it happened in many countries, which started already in 2014. And only in June 2021, last year, there was, after several intermediary small legal decisions, there was a first decision of a court of first instance, which granted or which said that indeed the Belgian and the regional governments, 3 regional governments in Belgium, that they violated the duty of care and human rights. So the case was won, but the judge, the case, did not put or decide on any concrete measures or targets. And so in November of last year, 2021, the non-profit organization, together with the 60,000 participants, also decided to go in appeal. So the case is still pending, let's say, and already for almost 8 years now. So it's a very long legal battle. But it shows that this is a really topical issue. It has been inventorized also in how many countries there are many, and also different types of climate change litigation cases. So very interesting. Maybe briefly on Hasselt University, small words. Our university was created in 71, but we started in 73. So we're going to celebrate our 50th anniversary next year in 2023. That will be a great year. As mentioned, we have 7 faculties. We have around 6,700 students, around 700 PhD students. And we call ourselves a civic university because we are very strongly connected with this region. This is a former mining region, also a region with a lot of non-EU immigrants. And so we see that as a university, we have a strong task to make sure that students, young students, pupils can go to the university, can study. But we definitely also moved very much from a university almost 50 years ago, focusing on education, to a university focusing also quite a lot on research. And I think this conference, what Matteo, Carole, and all of you are doing, but shows that we as a university also focus quite a lot on research. And they're also very successful in getting European projects, Interreg projects, etc. Okay, yeah, for those not physically here with us, a final invitation, come to Hasselt as soon as you can. It's a small but very cozy, beautiful city. And the location of the law faculty is a great location here in this old prison. I wish you a very good conference. I will definitely stay already for the first keynote, and I'll see regarding the timing, but I really look forward to it. So thank you very much.
Thank you very much, Bernard, for these warm and inspiring words. And now, ladies and gentlemen, we move forward to the first keynote dialogue of this afternoon on climate change, economy, and the courts. We welcome for this panel 3 eminent guests, Justice Luc Lavrysen, Professor Marten Ovaere, and Professor Michael Faure. Justice Lavrysen is president of the Belgian Constitutional Court and president of the European Union Forum of Judges for the Environment, Ovaere, a European environmental network. he co-founded in 2003 with Justice Guy Canivet, at that time first president of the Cour de Cassation of France, Justice Amedeo Postiglione, in those days judge of the Corte Suprema di Cassazione of Italy, and Lord Justice Robert Carnwath, at that time judge of the Court of Appeal of England and Wales. The forum was created with a view to raise the awareness of judges of the key role of the judicial function, of their judicial function in the effectiveness of sustainable development. Its annual meeting in 2017 in Oxford was devoted to climate change and the judiciary. Justice Lavrysen has been combining his career in the judiciary with an academic career at Ghent University, where he was a director of the reputed Center of Environmental and Energy Law for 2 decades, until September 2021, when he was admitted to the ranks of the Emeriti. As a professor of environmental law, he has been publishing on climate change law, governance, and litigation for several years already. Professor Ovaere received a Master of Sciences in Energy Engineering, a Master of Sciences in Advanced Studies in Economics, and a PhD degree in economics, all from the KU Leuven. He was a postdoctoral researcher at Yale University and a visiting researcher at the Toulouse School of Economics. Currently, he's assistant professor of economics at Ghent University, where he teaches environmental economics, and fellow of the Yale Center for Business and the Environment. He works on energy, climate, and environmental economic topics with a particular interest in renewable energy, electricity markets, and the European Union emission trading system. Professor Faure is the academic director of the Maastricht European Institute for Transnational Legal Research and professor of comparative and international environmental law at the Law Faculty of Maastricht University since 1991, nearly 3 decades. As a member of the Maastricht faculty, he's also part of this house, as the Law Faculty of Maastricht and Hasselt have, as our rector mentioned, structural affiliations. Professor Faure also holds a position at the Rotterdam Institute of Law and Economics of the Erasmus University in Rotterdam, and is academic director of the European Doctorate in Law and Economics program. And it is because of his law and economics that we invited him as a discussant today, and he should do a wonderful job. This for our panel, also some practical information, mainly aiming at the participants online, the online participants. Can you please submit your questions through the Zoom Q&A function only? This, I was reminded to ask this explicitly. So I would say, look, Marten and Michael, let's get started. Thank you.
Thank you very much, Carole, for this introduction. So I would like, in 15 minutes time, it was requested to give you a very broad overview of what's happening in climate change litigation in Europe, in the courts in Europe, and of course, of many of those cases, the panels coming this afternoon and tomorrow will go more in details. As Carole mentioned, our annual conference of the European Union Forum of Judges for the Environment in 2017 was in Oxford about climate change and the judiciary. And at that time, we took stock of what was happening at that moment. And I think we can say that we saw at that moment a gradual development of climate justice in some European member states and at the European level. Some member states, not all. And looking at those cases, most of these cases were very specific, dealing often with quite technical aspects of climate legislation, emission trading, support mechanism for renewable energies, incentives, and so on. Also already some cases about big projects, and some of those had some renown already at that moment. I'm thinking to the Vienna airport extension case, where the Supreme Administrative Court of Austria had found it illegal because violating the policies and the commitments of Austria in terms of climate change. But that case, that judgment has been overturned by the Constitutional Court of Austria in 2017. There were already at that time, 2017, some strategic cases introduced, one of them being Nature and Youth and Greenpeace Nordic versus the government of Norway. And this case was against 13 new oil and gas licenses in new areas in the Arctic Barents Sea. The final decision in this case came relatively recently because the Supreme Court of Norway decided on 20th of December 2020 and dismissed the case. The main argument being that future emissions from exported oil are too uncertain to prevent the granting of those licenses on the basis of constitutional rights, which were in principle recognized by the Supreme Court. And of course, we had already the Urgenda case, and just a quick reminder, that case had been introduced in 2013, so before the Paris Agreement. It's a civil procedure against the state of the Netherlands. It is based on the civil code and more particularly on the fault-based civil liability. And the claim of Urgenda was the state of the Netherlands has acted wrongly and negligently by not taking sufficient measures to reduce carbon dioxide emissions. And an injunction was requested saying the Netherlands should reduce their emissions with 25 to 40% compared with 1990 levels towards the end of 2020. And you have to compare it with the legal obligation under European law at that moment of the Netherlands, which was a reduction of 16%. So there was a first judgment of the District Court of The Hague. The case has been appealed, and the judgment has been confirmed by the Court of Appeal of The Hague, but on another legal basis. And finally, the case went to the Supreme Court, or Hoge Raad of the Netherlands. One must say that both the judgment, first instance appeal, was heavily debated amongst scholars, criticized, also saying those judgments are not respecting the separation of powers. The judge is taking the role of the government, of the parliament, etc. And secondly, there is no scientific basis why 25% reduction 2020. That's not scientifically based. However, these two critics were dealt with in a very detailed way by the opinions of two advocates generals. And finally, the Supreme Court confirmed the decision of the Court of Appeal. It's based on Article 2 and 8 of the European Convention of Human Rights and the United Nations Framework Convention. And as the critics are concerned, the Supreme Court said there is a broad consensus that developed countries should reduce their emissions with 25% by the end of 2020. And on the point of the violation of separation of powers, the court found there is no violation of the separation of powers by imposing a result-based injunction. Judges, that's their role, should provide legal protection as an essential element of the democratic rule of law. Then we had cases in other countries. Bernard mentioned already the Belgian klimaatzaak. So finally, there was a judgment of the Court of First Instance of Brussels in June last year, saying yes, the Belgian government have violated Article 2 and 8 of the European Convention of Human Rights, but there is no reduction target imposed. The court was of the opinion in doing so, the court or the judge would infringe the separation of powers, and as mentioned already, this case is appealed now. Ireland, case of Friends of the Irish Environment, with a final decision of the Supreme Court in July 2020, in which the court held that the National Climate Change Plan is largely insufficient. It's violating the Irish Climate Change Act of 2015, and more particular, the National Transition Objective 2050, which is in that act, and the court ordered that a new plan must be adopted. France, two important cases, the case of Ghent. Ghent is a small coastal town in the north of France. The case went to the Supreme Administrative Court, the Conseil d'État. It's based on French law and European Union law, which is read in conformity with the Paris Agreement. And the court came to the conclusion that France has committed itself to reduce the emissions by 40% by 2030. But the carbon budget, so in France, there are periodical carbon budgets which are adopted. That is an overshoot. The reduction to attain this objective, there must be a reduction of 2.2% a year, and there was only a reduction of 1% in that period. And also the next carbon budgets are not on track for reaching this objective, which is 40% in compared with 1990, or a reduction of 37% compared with 2005. The final decision came the 1st of July last year, and so the Council of State held that the refusal to reduce emissions in view of respecting this provision of the French code, read in conjunction with European law, is annulled, and the Prime Minister should take all measures to respect those targets before, and it's coming close this date, March 31st this year. Another case, Lafayette De Shackle. This case was before the Administrative Tribunal of Paris with a decision in February last year. Case brought by 4 environmental NGOs, and based on this new provision of the French Civil Code on ecological damage. And so the NGOs demand for imposing more ambitious objectives, but that was rejected by the court. The court said you have to stick to your commitments, but we cannot impose stricter commitments. And the final judgment is of October last year, and the tribunal ordered the government to take all necessary measures to repair the ecological damage by December of this year, end of this year at the latest. And the court has quantified the damage by at least 50 million tons of carbon dioxide equivalent, which has to be repaired, as the court says. Let's look at Germany. There we have the case of Neubauer, with a judgment of the Constitutional Court of March last year, in which the Constitutional Court held that the Climate Act of Germany is incompatible with fundamental rights because of a lack of sufficient provisions for further emission reduction from 2030 onwards, so for the period from 2030 to 2050. And The case is based on Article 20A of the Federal Constitution. It's a provision on climate action, which has been interpreted by the Constitutional Court in conformity with the Paris Agreement, saying this means we have to respect the objectives of the Paris Agreement. And the court held emission reductions may not be postponed because if you do that, large parts of carbon budgets will have been consumed, with a result that future generations will be confronted with a radical reduction burdens that exposes their lives to serious loss of freedom if you wait to cut your emissions. And so the court obliges the legislator to specify the emission reductions for the post-2030 period to achieve climate neutrality in 2050. And it's an order to amend, in that respect, the federal acts on climate policy. We can note also that natural persons have been recognized, and that's a little bit new for Germany, to have standing to protect their constitutional rights. But on the other hand, the court held environmental NGOs have no standing as so-called advocates of nature. Then we have the European courts. The first important case for the General Court and the Court of Justice of the European Union, Carvalho and others. This case failed because the court was not willing to review its Plowman test on standing, from time to time also called the Kafka test, because it's very strange thing. But the case did not survive that test on standing. And then we have Strasbourg, European Court of Human Rights. There are now 3 important cases pending. The case of Duarte Agostino and others versus Portugal and 33 other states in which the written procedure is over. So the case can be taken by the Grand Chamber now for a decision. We have also the case of Verein van Klimasenioren Schweiz versus Switzerland. So that's the Swiss grannies case because the Supreme Court of Switzerland denied standing for them. And then we have the first case discussed. Also the Greenpeace Nordic and other case is meanwhile referred to the court. There are also big project cases. We have the case of Heathrow. We have a first decision saying the extension of the decision to extend is illegal because one has not looked sufficiently to the engagements taken under the Paris Agreement, but this decision has also been overturned by the Supreme Court of the United Kingdom. We have cases about conduct of major companies, with a first important case, I think, again, of the Hague District Court, Milieudefensie and Allies, in which the court orders Royal Dutch Shell to cut their carbon emissions by 45% by 2030, and all emissions, direct and indirect emissions. Also, I think Royal Shell is not so happy about that decision. There is an appeal, and I've read that they are moving headquarters also to London from Amsterdam. I don't know if that had something to do with that case. I come to my conclusions. I think some general principles can be deduced from the different cases. First, the protection of life and health includes the protection against environmental pollution, which is case law of the European Court of Human Rights, is confirmed by the Supreme Courts in different member states. Human rights, it's also case law of the European Court of Human Rights, constitute a positive obligation to protect against environmental harm. And here, in these cases, one concludes that harm resulting from climate change is covered by those provisions. Third, emission cuts must not be postponed to later. That's often heard. In 10 years, 20 years, we will have much more better technology, and so we can do the job over there. No, we can conclude of those cases that will be problematic if only a short time is left for radical transformations at that moment. Next, to reduce emission is an obligation, even if the state's share in global emissions is small. Often the argument is the emissions from Belgium, it's only 3%. If we cut that with 10%, then it's nothing. Look to China, India, and so on. The decades to come, what will bring? I don't have a crystal ball, but maybe one can say nevertheless something. I think national courts will increasingly be confronted with climate cases from different types, projects, and we see it more and more. Also in Belgium, we have some cases. Policies will be scrutinized, both public policies, private, major companies. I think more and more important because climate change is happening also today. I think with the storm is coming. So adaptation measures must be taken, but these measures will also impact life of people and so on. I think we will see cases around that. And third, we see it now, so the last summer, with the floodings we had in Germany and Belgium. One is questioning, have the government taken sufficient measures to protect the people? Have they alerted the people on time for evacuation? And so there are criminal investigations going on both in Germany and in Belgium around that. And I think that will come, we will see that more and more. And then the next case we have, let's say, nice judgments. You have to reduce your emissions. But now the next question comes. That was, I think, not a surprise that on 31 of December 2020, the Netherlands had not respected this 25% reduction. What now? How to enforce those targets? And if one has to make a plan, like in Ireland, how to implement that plan, etc. So I think this will give again rise to cases, and judges shall try to figure out what can they do in such a situation. And finally, I think what the European Court of Human Rights will decide, I think in the coming months in the cases will be very important because they will clarify or Article 2 and 8 of the European Convention suitable grounds to found such claims. If the court say yes, then I think this will give rise to other cases. If the court say no, I think that will be also impacting probably the jurisprudence of national courts. Thank you.
Thank you very much, Luc. And now it's up to Marten. Thank you.
see if this works. Just 1 second.
Thank you. I'm Marten Ovaere. I'm another legal expert. I'm an economist. That's also how I'm going to approach this topic. So I'm going to look at the potential effects of litigation on long-run emissions. Next slide, please. So first, I'm going to introduce a long-run view on economics, an economic framework. That means supply and demand graphs. That's 101 economics. And then how to look at climate litigation starting from this framework. Next slide, please. So this is a long-run supply curve of oil. So on the horizontal axis, you see total reserves of oil. And I use oil as an example, but you can look at natural gas, coal, any commodity. So what do you see? At first, it's really cheap to extract some oil in the Middle East, for example. It's just flowing out of the ground more or less. And the vertical axis is the price of the cost of extracting this oil. And as you go up to other regions, the price also goes up. If you want to extract shale oil, offshore drilling, tar sands, the price goes up. That's why this curve is sloping upwards. Next slide, please. On the other hand, there's the long-run demand for oil. And this one is sloping downwards. So at first, we need oil for shipping, for aviation, and then chemical industries using oil, heating homes, road transport, electricity, increasingly less, but still being used. And shipping aviation is at the top, electricity at the bottom, because shipping aviation are the ones that have the least alternatives to use alternatives for oil. Next slide, please. So if you want to decarbonize shipping, right now, I would say the prevailing narrative is we will use green hydrogen or some other hydrocarbon. Heating homes, the alternative is heat pumps, more and more being used. And electric vehicles, you want to decarbonize road transport. And electricity, there's gas, there's solar, there's wind, plenty of alternatives. Next slide, please. And so now where those two intersect, that's our equilibrium. So that means right now, if these two illustrative supply and demand curves are reality, this will be the total amount of reserves that will be extracted from the Earth. So where the dashed line is reaching my horizontal axis. And also interestingly, this means actually that the lower the price in the long run, the more oil, natural gas, or coal will stay in the ground. So in a sense, from this perspective, in the long run, low price is good. Higher prices mean that they will go out and explore for more oil, more natural gas, and more coal. So high prices, low prices is good, not a bad thing in this framework. Next slide. So carbon budget, already mentioned by Professor Lavrysen. These are our carbon budgets for different likelihoods of reaching a certain degree of heating and years that we have left at the current rate. So let's say we aim for 1.5. We have around 11 years of current rate left. Next slide, please. Putting that on another point is comparing this budget with actual reserves in the ground. So it was around 400, I guess, carbon budget for 1.5 degrees heating. Well, the proven reserves of oil and gas, that's the actual reserves in balance sheets of companies, is around 300 gigatons of CO2. If we add all the coal reserves, it's around 3 times more than our carbon budget. If we add all our resources that we think are in the ground or that we already know are there, not yet in balance sheets and not yet really covered, this is an order of magnitude high. Next slide, please. So let's say this is our carbon budget. Let's say this is the amount of oil that we can extract. What do we need to do? Next slide. The question is, what do we need to do? That's a big question. Next slide, please. What do we need to do? Well, we have to shift up our supply curve and shift down our demand curve. I think that's the general essence of all of this. And how do we do this? Next slide, please. For supply, what are the policy tools, the measures that we have to implement? Things like a tax, a cap and trade, ban exploration in certain areas, have a cap on extraction or the extraction rate. All those things make supply more expensive. On the other hand, next slide, there is demand. How do we make demand more going downwards? Well, make alternatives more appealing, more cheap. So subsidies, mandate alternative, support R&D to make it a more cheap, ban oil consumption like Europe will be doing in the next decade for gasoline-powered cars. All of this pushes that downwards. Next slide, please. So I think that was, I hope that was clear. Now let's look at how climate litigation will affect these curves. And I will borrow a bit from this very interesting report about global trends in climate change. Next slide, please. So mirroring a bit what Professor Lavrysen was saying, who are defendants in these cases? Well, mainly federal governments, that's clear, but also some corporations and few individuals, according to this report. Next slide, please. So first of all, federal and subnational governments, it's usually about you are not doing enough. The climate commitment is insufficient. Case in point, Ghent versus the Netherlands. So what does that affect? Next slide, please. In this case, we require the Netherlands, in this case, to reach a certain carbon budget. So they are free to do what they want, supply or demand measures. A side remark is that, of course, Belgium is not alone in the world. So actually, if we zoom in on just Belgium, it will be just a slight, or Belgium and the Netherlands, will be just a slight change of these two things on the right. True, but of course, that is like a typical climate narrative that we should avoid, I think, because that brings us nowhere. But so it means the government has to implement policies, all kind of more ambitious supply and demand policies. to move this up. Next. A lot of cases are also about authorizing specific activities or projects. Case in point, people versus Arctic oil. So next slide, please. This is pretty straightforward to show. So if we can force some oil resources higher up the supply curve to just stay in the ground, we shift, in this case, let's say the Arctic oil reserve is the red area. We shift up our supply curve to the left a bit, if that stays in the ground. And this is also a more long-term, I would say, commitment than these other policies. Next. And of course, there's also the opposite. Apparently, there's many cases that want to push them down again, like supply policies down again, and demand policies up again. Next. Then against corporations, and this is where it gets more interesting. It's mainly against the carbon majors. Case in point, Milieu Defense Shell. And this is they have to reach minus 45% net decrease by 2030. It's a result obligation on scope 1 and an efforts obligation scope 2 and 3. What are some of these effects? Next, please. There's a direct effect, I think, and an indirect effect. So a direct effect, looking at the case, is that they're not allowed new explorations in areas where Shell is not yet present. So in a sense, this will decrease exploring some new reserves, adding to that up to the 1200s already proven reserves, but still. What else? Higher financing costs, probably for Shell. It's not as easy to get funding for new projects. Also more investment in green alternatives, because they have a lot of cash. They will not use it to explore, but to invest in renewables. So that's clearly shifting down that demand curve in a more long run effect, I would say, because R&D investments are for the long run, decreases in solar, offshore wind, onshore wind. But of course, there's always the case, what share of that minus 45% decrease will be taken over by competitors? They can, and they have been doing that. They can just sell off some of their reserves, for example. They are 2% of worldwide emissions right now. Also, the indirect effect, I would argue, consumer awareness, and also competitors fearing the same things if they take over reserves high up the supply curve in Arctic, offshore, tar sands, those kind of things, because they fear to be sued as well. So that I would say has an effect on both supply and demand. Next slide, please. Yeah, so that's just what is happening, I would say, on the margin for Shell. Next slide, please. Then there's been a few cases against large emitters. For example, there's a case against a meat and dairy producer that's clearly pushing down the supply curve. That case was essentially dismissed, and I would argue the effect is very low anyway. If you go to the secondary emitters, like the ones using energy to do something else, we still need dairy, for example. It takes more than closing down the dairy plant, I would say. It's less fundamental than against carbon majors are really the ones exploring, and that's what we don't want, more exploring, because we already have enough reserves. Next slide, please. And this is, I think, my last one, against high emitting projects. I think that's very effective. For example, Client Earth against a very, very large Polish coal plant, actually the largest coal plant in Europe. It has a lifetime of 1 gigatons of CO2. I don't think it's carbon, it's CO2 over its lifetime. And the direct effect is that plant will have an expedited closure, which means less coal consumption, which I would say drives down the price of coal on the margin, which means less exploring, etc. Next slide, please. So yeah, this is what's happening in this case. There will be less demand for coal. Of course, we still need electricity. There will be some gas, some solar, some wind, but on the margin, I would say proposing coal plants has a long run effect because you're pushing down the price on the margin. And next slide, please. Yeah, a final case or type of cases is against financial market actors. So Rest is an Australian pension fund. In this case, one of the people having a pension in their fund asked them to be more, I would say, take into account the effects of climate change in their policy. And the effect of this, next slide, please, is that there will be less financing towards carbon emissions and more towards green alternatives, which means pushing down the cost of alternatives, create less financing for exploring and doing carbon emissions, pushing up the supply curve. I think it was my last slide, but next slide, please. Yes, thank you.
Thank you, Marten, for this very interesting and accessible analysis economic analysis of the impact of climate change litigation. And now the floor to Michael as discussant. Thank you.
Thank you very much, Chair. Well, let me say immediately that I will not take the role of a classic discussant in a law and economics conference who comes with all kind of nasty critical comments to say how wrong the assumptions were in the papers and that we should fundamentally review all of the paradigms on which these papers are based. To the contrary, I think that both papers are excellent and that I enjoyed them a lot and that they were very insightful. I think the way that Luc provided the overview of what is going on, for me at least, I found it very interesting and that you really get almost an aha feeling like, wow, it's impressive. This is not only Agenda, Belgium, France, where I was aware of, but that you see also Ireland in the Nordic countries, Germany, and that Luc could also make some parallels, point at what's going on at the European Court level. Really impressive. And what I liked about Marten's story is that he also shows, well, there are economic effects. Litigation has an influence on supply and demand curves. So it may be that there is an influence, maybe not enormous, but there is at least a marginal influence. So let's say that my comment is a simple one. I congratulate both speakers because I think this is a very insightful and interesting introduction from a legal and from an economic perspective. Also with a view on time, because we only have 5 minutes till the next session, I will just do two things. First, Carole was so kind to introduce me as someone who has as a hobby the economic approach to law, also called law and economics. She said that that's the reason I was invited, so then I should sing for my supper, as we say, right? Now, what could we say very briefly from a law and economics perspective if you look at climate change litigation? Well, it's a bit ambiguous in the following sense. If you look at some of the literature, and I mean Susan Rose Ackerman, Steve Chevelle, all those who have asked the question, should regulation of hazardous activities, including greenhouse gases, should that primarily take place by administrative agencies or by the courts? All of these authors overwhelmingly argue that there is the assumption that these agencies are acting in the public interest, and when they act in the public interest, they will set optimal care standards. Why? Because agencies can do this using, let's say, economies of scale and have better information to set optimal standards. And so what basically this literature says, we should avoid that later in a tort case, a civil judge starts second-guessing efficient agency decisions. So let's say that the basic assumption is agencies have more and better information than civil judges. So a primary decision with agencies either to set standards in a command and control approach or via a market-based instrument like emission trading. But this whole literature is based on one important assumption, being that standards are set in the public interest. And of course, here the problem is that you then assume that what the government would do, for example, with an emission trading scheme, is set efficient standards that are able to cure the problem in an adequate manner. Of course, if that condition is not fully met, why would that be the case? Well, it may be that there is effective lobbying by industry. And there is a whole different stream in law and economics, as Marten well knows, public choice, that puts the stress on the private interest effects on regulation. So let's say if you look at these authors, they would say, but how can you assume that, for example, an ETS or other mechanisms, that they would set standards that would necessarily be optimal standards in the sense of curing the problem of climate change in an effective manner? And if you believe that, then you can make a story. Okay, maybe then the standards that are set at the government level, either in a market-based instrument, or if a country would have a taxation, we don't have that much of it, maybe those are not the optimal standards. And if that is the case, then you get an important argument to say, well, there may be a complementary or there may be a supplementary role for tort law. Why? Well, the judge has an enormous advantage which public agencies do not have. Judges are not subject to capturing and to private interests. So in that, or at least, let me say less. So in that sense, let me just say, if you look at this from a positive perspective, you simply ask the question, can we understand from a law and economics perspective why you see climate change litigation? My simple answer just in these couple of sentences is, yes, I can understand. It may be that what the government has said, for example, in an ETS or maybe in other instruments, that maybe that care level was, for a variety of reasons, not the optimal care level. And that maybe also, for example, because often the standards set by the government are static, are not dynamic, whereas technology evolves. And the nice thing about tort litigation can be dynamic and can much more rapidly also adapt to increasing levels of knowledge in changes in technology. And so if you then say, I'm using now tort litigation to force maybe the government to come to a higher level than what they originally agreed to, then I would say from a law and economics perspective, that makes perfect sense. Now, that means it makes sense in the sense that you can understand why you see climate change litigation and why victims turn to courts to ask governments to do more than what they did. Another thing is, of course, whether everything that happens in the court decisions is always totally efficient and out of question. That's a totally different story. Because logically, as Luc was saying, you can easily raise, and I will do so, lots of questions on, let's say, the whole climate change litigation. And Luc knows it. I mean, if we see Lucas Bergkamp, who almost writes a blog every day to say that the judges in The Hague are crazy. I disagree with Lucas, with all due respect, I have to say. But he is very active in saying that these decisions of the century are the mistakes of the century, and he has wonderful language to make that clear. So the question is a little bit, how do we deal with all of these questions? You know, what are some of the critics? Obviously, the separation of powers. Luc already mentioned it, and mentioned that also the attorneys general in the Urgenda case tried to respond to that in an adequate manner. I would be interested to hear, if we have time, how Luc himself would feel about that. If indeed this is not an issue of the separation of power, for the simple reason that judges are not taking the decision themselves on what would be optimal reduction measures, but simply put it back to the government to take further going measures. The other issue is, of course, what about the expertise of the judiciary? And here, one of the questions I also have, couldn't we also look a bit more at other cases of public interest litigation outside of the climate area? For example, in India, the whole of environmental policy has been made by the Supreme Court of India. In all of these cases, Mehta versus State of India. And there also there was criticism, but there we saw that the court used all kinds of mechanisms, technical committees to get expertise, and on even economists write that the decisions were effective in the sense that they led to reduction of emissions. So can we learn from that? And then also, I mean, other things that I'm thinking about, Marian Peters, my dear colleague present here in the room, always tells me, and I think she might be right there, shouldn't the judges also have asked prejudicial questions to the European Court in Luxembourg? Because isn't it the fact that you simply say, okay, the ETS is not going far enough, are you then implicitly not asking a question about the effectiveness of European law? And should you then, instead of deciding yourself, not first bring that to Luxembourg? And I think that Marianne puts that question rightly so. So that's also an interesting issue. What I would also be interested in, if we look at all of these different foundations for the cases, sometimes they use administrative law, sometimes it's human rights, sometimes it's tort law. if you now would advise the NGOs, to put it simple, which of the roads would be the most effective one? Or is it a combination, like in Urgenda, stop or 5? What was
5.
Ah, okay, I thought the sign was like an Indian. No, okay. 5 is no problem, I'm almost done. A question I also have, so far, most of the climate change litigation cases we saw were requests for an injunction, either against, Luc mentioned it so nicely, corporations, or against public authorities to do something. What about compensation cases? Of course, it's difficult, but we see already countries like Tuvalu who are claiming, and rightly so, my whole country is going to disappear, and I have serious damage, which is a fair case. And so how would they think about the likelihood of those cases being successful as well? And logically, there are also questions on, and Luc already alluded to that, when you have a decision like Urgenda, it looks wonderful, but what about implementation and what about enforcement? Who is by the end of the day going to control whether there is compliance with such a decision? If you just have an order to do something, but then it leaves a lot of freeway. My dear chair, I see you looking at your watch, and I do the same, and I could have many more questions, but let me just end by congratulating again the two speakers with fascinating talks, and have no doubt that there will be more questions from the audience or from the people listening online. Congratulations, dear speakers.
Thank you very much, Michael. And also, do we still have some time for some questions out of the room?
It happens, we have very little time. We have a lot of questions online, so I will ask the keynote speakers to briefly address Michael's question, and then we will see about the time, because we're very much running behind schedule. So if you want to take on Michael's question, you still have time.
There was more than one question, I think. The first one is expertise, and you said referring to this law and economics people, agencies, governments have better possibility to acquire the right information. I would say that's correct if you have a good working agency, and I must say that's not always the case. Secondly, in a court case, let's say science is brought by the parties, and the parties will rely on reports of the IPPC, of the COPs, other scientific bodies. So I think at the end of the day, simple judges start to understand the problem. And then we have the second point, separation of powers. Looking at those Supreme Courts who have discussed the question, now for the moment, the consensus seems to be there is no violation as long as you stick to objectives, targets, etc., and you leave choice of instruments, how to the burden of these measures, which social measures, etc. That's a matter of politics, and indeed, I think judges don't have the knowledge, and they are not accountable to the people, like politicians are elected, etc., to take those decisions. So I personally, I would be very reluctant to say, government, you have to take that measures, more trains, less trams, more, etc. I think that's not up to the judiciary to decide. And then, of course, I mentioned already the question of enforcement of those judges. I think also judges, but also parties who bring cases will have to learn and also look to what's happening a little bit around the world. You spoke about India. I will speak about Pakistan. we have an instrument like mandamus and the case of Lafayette, for example, in Pakistan. There, the court appointed a commission, etc., and they have to report regularly to the progress, etc. That could be an instrument. That could be an instrument to improve enforcement. And then the last question: should, in the Urgenda case, should why not have referred the cases to Luxembourg or to Strasbourg? I think not Luxembourg, because the obligations under European law are minimum obligations. So as long as you respect the minimum obligations, there is no issue of European law. The other cases, of course, Article 2 and 8 of the European Convention of Human Rights. And there you have now the possibility to have these preliminary opinions. I think the Netherlands have already ratified the 16th protocol. In Belgium, our government decided last Friday to go for, and there I think the Supreme Court has discussed the issue in the Netherlands and saying, if we do that, and even there is a sort of fast track procedure in Strasbourg to tackle these cases, they would not be able to have a effective judgment before the date that was requested. So that was, I think, the main argument. But as I said, in some months' time, we will have the answer on the basis, I think, of the cases who are pending now. Thank you.
Quickly, first, I agree with Luc. A few small remarks. I think the choice of instruments should really be a government choice, because you really need an army of experts to design and calibrate all these policies. That's one comment. And secondly, focusing on EUTS, because that's my expertise. I'm a big fan of EUTS. I think it's highly effective, highly efficient. But that being said, also the stringency, the commitment, I would say European Union is a front runner. So they increased the ambition to -61% by 2030. It's the target of the EUTS, which is higher than, for example, the ruling in the Urgenda case. So in a sense, I think that shows that the front runner, the one that is pushing the boundary, is the European Commission, the European Union, and I think rightly so.
So thanks to all of you. It is my task to pass on at least one question coming from our 133 participants online. And we have a rather special one from Roda Verhaayen, asking to our panelists, I would like to know if the panel considers the time ripe for a case in an international court and what they see the hurdles to be. Rather big question, rather small time to answer.
I'm not an international lawyer, and I'm not able to give a sensible answer, I think, to this question. If going to the courts, another court in The Hague, the International Court of Arbitration, or another court, Law of the Sea, and so on. I think maybe Michael mentioned Tuvalu. For those, I think maybe there is an avenue because there you have indeed international law, which is the only law you can rely on. But I think, speaking in general about national policies of multinationals, etc., I'm a little bit I'm not convinced that international courts will bring the solution. That's my opinion without being an expert in this issue.
Thank you, Luc. And I think just looking at time running forward, we really have to close this keynote session with those last comments of Luc. Many thanks to Luc, Marten, Michael for their input in this discussion.